So what really gives a police officer the right to stop you on the street or pull you over in your car? Is it just a gut feeling they have, a hunch? Or does there have to be something more concrete? Well, that's exactly what we're going to dig into, that critical line between an officer's intuition and the actual law, a line that's there to protect your rights.
Okay, let's jump right in with a super simple scenario. Picture two different people, both getting stopped by the police. On the surface, the situations might look similar, but what makes one of these stops totally legal and the other a potential violation of your rights? It all comes down to the reason for the stop.
So on one side, you've got Alex. The officer's reason is pretty vague, right? You just seemed out of place. I had a gut feeling. That's a hunch. But then you have Ben. The officer lays out specific observable things, weaving between lanes, expired registration. Those are facts. And this difference, right here, is absolutely everything. It's the foundation of what protects you from just being stopped for any old reason. Alex's stop? Probably illegal. Ben's? Totally by the book.
And the difference boils down to this one crucial legal phrase: articulable facts. Now I know, it sounds like a bunch of legal jargon, but it's actually pretty simple and incredibly powerful. All it means is that an officer has to be able to articulate the specific real-world details that made them suspicious. This isn't just some technicality, it is your legal shield against being stopped on a whim.
Now here's the really wild part. You can read the Constitution front to back, and you will not find the words articulable facts anywhere in there. Nope. This whole standard, this cornerstone of police procedure, was actually born from a huge legal showdown in the 1960s that completely changed the rules of the game.
See, before this big case, the law had a massive gap. To actually arrest someone, police needed probable cause, which is a really high legal bar. But what about just stopping someone on the street who looked suspicious? For that, there was no clear standard at all. It was a legal gray area, and it was creating a whole lot of tension.
And that brings us to the case, Terry versus Ohio. Picture it, Cleveland, 1968. A veteran detective sees two guys pacing in front of a store, looking in the window, walking away, and coming back again and again. His gut tells him they're about to pull off a robbery. So he confronts them, pats them down, and yep, he finds guns. One of the men, John Terry, gets convicted, but he appeals, arguing the cop had no probable cause to stop him in the first place. The case ends up at the Supreme Court, which now has a giant question to answer.
So the court had to create a new middle ground standard. And this right here is what they came up with. They ruled that, yes, an officer can stop someone without probable cause for an arrest, but only if they can point to specific and articulable facts that justify it. And boom! With that one sentence, the Supreme Court created a whole new rulebook for policing and handed citizens a new form of protection.
So what does articulable facts actually look like in the real world? When a stop gets challenged in court, a judge doesn't just take an officer's word for it. No way. They put the reason for the stop under a microscope, and they look for a few key ingredients. First, there's specificity. An officer can't just say he looked nervous. That's a conclusion, not a fact. But his hands were shaking and he was sweating profusely. Now those are specific, articulable facts. Second, objectivity. The court asks, would a reasonable officer have felt the same way? This helps filter out personal biases. And third, and this is a big one, is the totality of the circumstances. It means you have to look at the whole picture.
Let's build a quick scenario to see exactly how this works. Fact number 1. A man is standing on a street corner at 2 in the morning. By itself, is that suspicious? Not really. Perfectly innocent.
Okay, now let's add another piece to the puzzle. He's wearing a ski mask, but it's a warm night. Okay, that's a little odd, right? It definitely adds to the picture.
And now, fact number 3. He's holding a crowbar. See how the context just completely changed? We've gone from an innocent situation to something that feels pretty sketchy.
And this is the perfect example of what we're talking about. Each of those facts, on its own, could maybe be explained away. But when you put them all together, the late hour, the mask, the crowbar, they paint a pretty clear picture. That combination creates a strong, articulable basis for an officer to have a reasonable suspicion that a crime is about to go down. That's the totality of the circumstances.
Now here's a really important thing to know. The Terry v. Ohio ruling set the minimum standard for the whole country. It's the federal baseline. But individual states can actually give their citizens even more protection. For instance, federally, a detailed anonymous tip might be enough for a stop, but in a state like Massachusetts, their courts have said, nope, not good enough. An unconfirmed tip alone won't cut it. The police have to observe something suspicious themselves.
Okay, so knowing the law is great, but knowing what to actually do and say during an encounter is just as important. So let's shift gears and talk about a practical playbook for how to handle yourself if you're ever stopped.
Here are 5 steps that can really help. Number 1, and it's the most important, stay calm. Safety is everyone's priority, so keep your hands visible. Number 2, comply with lawful orders, like providing your ID if you're required to. Number 3 is where you use a couple of key phrases to calmly assert your rights. We'll get to those in just a second. 4, observe everything. Try to be a good witness to your own encounter. And finally, step 5, as soon as it's over, write it all down. Those details could be absolutely critical later.
This is the first powerful phrase you should know. Asking, am I being detained or am I free to go, is so important because it clarifies the entire situation. It forces the officer to tell you whether this is a voluntary conversation or a legal stop. If you're free to go, you can leave. If you are being detained, the officer is now on the clock to justify it with those articulable facts.
And here's the second key phrase. I do not consent to a search. Police can always ask for your permission to search you, your bag, or your car. You have the constitutional right to say no. Stating clearly and calmly, I do not consent, is how you exercise that right. Now, don't ever physically resist if they search anyway, but make sure you've made it verbally clear that you do not agree to it.
You know, this legal standard was created more than 50 years ago, in a completely different world. And today, it's being tested like never before by new technologies and new debates, raising some really tough questions about what our rights will look like in the future.
You have the ongoing arguments around racial profiling, where many argue that vague reasons for a stop can be used to hide bias. Then you have technology like body cameras, which are a total game changer because they can provide an objective record of what really happened. And the newest frontier? Algorithmic policing. Police forces are now using AIs to predict crime hotspots, which forces us to ask what suspicion even means when it comes from a computer.
And all of this leaves us with a huge critical question for our time. Can a police algorithm have articulable facts? The entire standard was built around what a reasonable human being could see, process, and explain. So what happens when the suspicion doesn't come from a person, but from a piece of software? How we answer that question is going to define the line between security and freedom for a whole new generation.